Good afternoon, everyone, and welcome to the CLE seminar, Single Transaction, let's try that again, Single Transaction Guardianship, sponsored by Fidelity National Title and Commonwealth Land Title of North Carolina. Together, we are a part of a family of companies that collectively issue more title insurance policies than any other title company in the United States. I'm Julie Lamond, Administrative Coordinator in support of the great service our underwriters, managers, and representatives provide in your community. Today, we are fortunate to have Catherine Wilson, partner with McPherson, Rockamora, Nicholson, Wilson, and Hinkle in Durham. Her practice centers on estate planning for persons with special needs, guardianships, fiduciary litigation, and complex estate administration issues. Her special needs practice includes assisting with planning for family members with special needs and also the post-litigation establishment of special needs trusts designed to receive personal injury awards. She earned both her law degree and a Master's of Theological Studies from Vanderbilt University in 2005. Upon graduation, Catherine practiced in the areas of trusts and estates in a private firm. She is a member of the American, North Carolina, Alabama, and Durham Bar Associations, and is a member of the Estate Planning and Fiduciary Law section of the North Carolina Bar. She also serves on the board of the 14th Judicial District Bar, the Durham County Bar Association, and the Durham Bar Foundation. If you have technology or content questions, you'll see in the bar probably on the right side of your screen, there's a block for chat, and I'll be monitoring that. There's also a section for questions, and I'll keep track of that. We may save those questions, but I'll be looking at those, and if there's time at the end, we'll review those. And we also have a few polls today, so jump right in and use your keyboard, and I'll share the results instantly in aggregate form. It's fun for us and makes the State Bar happy. If you are participating by phone only without video access, you're missing a valuable part, but no worries. Please reach out to me after the session to confirm credit and receive a copy of the slides. Also, if you're watching with someone else and you're using one login, let me know that as well. I want to make sure everyone gets credit for this. So, this wonderful program. Catherine, I will turn the program over to you.
All right, thank you, Julie. I'm going to pull up my screen, and Julie, just let me know when I'm screen sharing with the group.
You are, I think you have to say yes. You see it?
I did, yes, and I clicked on it. I'm going to pull up my PowerPoint. Okay, great. Are we good?
We're good.
Fantastic. Well, hello, everybody. Thank you for taking time out of your day to join us. Thank you to Fidelity Title for having me and for inviting me to speak. This is a subject that you guys can probably tell I'm pretty passionate about and I really enjoy. And another little tidbit, I work pretty heavily. I'm involved in North Carolina Bar Association, the Estate Planning and Fiduciary Law Section's Legislative Committee, and I'm actually serving as co-chair for the next several years. And so I worked a lot on drafting this statute and getting it through the legislation process. And so I'm really happy to share with you this addition to our guardianship statutes and what it means for all of us and how we can use it, I think, and benefit from it in our practices. So first of all, I just want to you may have seen the two different titles. So sometimes I will refer to this, and in a previous article, I called it a single transaction guardianship. That is kind of a term of art, but it's not found in the statute. But sometimes these types of arrangements are known as single transaction guardianship provisions or statutes. North Carolina is not the first to have one around the country. In fact, we're between 20 and 30 states now that have these types of statutes. And so we just tried to steal from the best as we were looking at other states around the country and what we thought they were doing well in their guardianship statutes and things that we would like to include and specifically options. But technically, the correct term, and you'll see this in the statute, is single protective arrangements and single transactions. And that's why it's up on my screen right here. And this is really in place of a guardianship. But before we get into kind of the nuts and bolts of that, I think the first thing is let's kind of review the basics of guardianships in North Carolina, and particularly guardianships prior to October of last year, because this is when this law took effect. So just a cursory review. With guardianships in North Carolina, they are governed by Chapter 35A of the statutes. That contains our entire guardianship section of our statutes. They are designed to protect individuals who are unable to manage their own affairs or communicate their own decisions, specifically as it relates to their property, their person, their family, healthcare decisions, residential decisions. They can manage person or property. Sometimes they manage both. So we may have a guardian of the person to manage residential and healthcare decisions. We may have a guardian of the estate to manage property and business decisions. And we may have somebody that does both. And in that case, we call them the general guardian when they're wearing that guardianship of the person hat and the guardianship of the estate hat. The important thing to remember, especially prior to October of last year, is this was a one-size-fits-all proposition. If you needed any part of the guardianship process, you were going to have to sign on for all of the guardianship process. And in the case of managing somebody's property or business affairs, what that meant was that you were going to have to create a guardianship of the estate. You're going to be subject to annual court accountings and reporting requirements. You'll have to get certain permissions to do certain things with respect to how you spend money and what you can do with the guardianship. And it's an ongoing proposition where the reporting requirements are going to be going, until the court turns off the guardianship and the guardianship is terminated, whether it's a death of the individual or if certain circumstances arise down the road. So it's a lot of work. It is a very necessary thing. It's very useful for North Carolina citizens, but it is a large undertaking. So that begs the question, what if you just need to do one thing? What if you've got one goal that you're trying to accomplish, particularly when it relates to property or business affairs of an individual? And so here I give some examples, and you'll see in the manuscript, I kind of go a little bit in more depth in these examples, and they come up at different points in the manuscript. But let's say we need to sign a contract on behalf of an incompetent spouse. Let's say that this couple, the competent spouse manages all the joint assets and handles everything for the two of them, and they really don't need anything else except for authority to sign a particular contract to settle a particular issue. That could be one example where we are going to have to utilize guardianship, but we only need to do one thing. Also, what if, let's say we've got somebody who is receiving supplemental security income from Social Security. We call this SSI, which is a government benefit that has very specific rules and requirements. And they're receiving Medicaid as well. And they inherit property. Maybe it's an entire piece of property. Maybe it's an interest in property that they're sharing with other relatives. And we need to deal specifically with that asset, and maybe the goal is to sell it. But that may be an example too of where we need one aspect of the entire guardianship framework. Another example, I think that, which is a pretty common example, is somebody is trying to spend down their assets to qualify for nursing home assistance and specifically Medicaid assistance. So we've got one goal in mind, which is to get assets under a certain countable resource limit so that Medicaid can be turned on in the nursing home. So these are all examples of, we just need one part of the guardianship process. But prior to October 1st, 2021, this is what would have to happen in any of the above situations I just described. We've got to petition for adjudication of the individual, because I'm assuming we've all got adults in these situations, and we're going to have to adjudicate them to be incompetent. And then a guardian is going to have to be appointed, and we've got to qualify as a guardian of the estate to be appointed. Then we've got to do step 3, we've got to file a motion in the cause for specific relief. So now we've got a guardian appointed. Now we have to go back to the court and ask for what we really want them to do, whether it's sign a contract, whether it's to deal with this inherited property of a special needs beneficiary, whether it's Medicaid spend down, whatever. We got to go back and ask for that specific permission. Then we get the order. then our guardian is going to carry out the provisions of that order, accomplish whatever they're trying to do. They're still going to be subject to reporting requirements. So they're still going to have to file a 90-day inventory like every guardian of the estate would have to do. Then they don't need to keep an ongoing guardianship if they've accomplished the single purpose that they set out for. So the next thing they do is they'd go back to court yet a third time and ask for the guardianship to be terminated, because we don't need an ongoing guardianship of the estate. And then if that's granted, then it's going to lead to one more step, which is before they can be discharged, they've got to file a final account to be completely done. So it's a lot of steps to do one specific thing. And so as we looked at other states and what they offered as far as a way to give kind of a procedural shortcut and to save time and resources, we discovered this concept of single transaction guardianship. And so now we've got a new section of Chapter 35A. This is section 1121. So sometimes I'll just call it 1121. Sometimes we'll call it a single protective arrangement or single transaction statute. But what it does, it's right up here on the screen, it authorizes the clerk to order a single protective arrangement or single transaction for the benefit of a minor or incompetent person without appointing a guardian. So remember, in North Carolina, we kind of have a bifurcated guardianship process. So when somebody is adjudicated to be incompetent, then the old version of the statute said, all right, from that point, we've done step one, and step two is we figure out who is the guardian that we have to appoint. And there was no way to break that process. You adjudicate somebody incompetent, the very next thing is you have to appoint a guardian for that person. What 1121 does, and if you look at the statute just before it, 1120, it interrupts that process. So we can adjudicate somebody, the court can pause and say, is a full guardianship necessary in a particular situation? If it's necessary, great, we're going to do what we always do and go on to appoint a full guardianship. But if we don't need a full guardianship, if we don't need that type of accounting and reporting and ongoing management, I think is really the key, then the court can pause and just enter an order allowing a single protective arrangement or single transaction. It doesn't necessitate the appointment of a guardian. So all those additional steps and going back to court, the idea is now that we do it in one transaction, one proceeding, or as few transactions or proceedings as possible. And I'll explain what I mean by that in just a minute. Okay, if we have this new type of relief, which sounds really great, when can it be used? Well, it's two specific situations, really. The first one is if it is a transaction necessary or desirable for any service, care, or safety arrangement. So I refer to these as kind of the person-centric needs. If somebody needs shelter, they need caregiving, we need to make sure they're safe, whether it's living in a particular environment, whether it's giving them services for their benefit, or just making sure they have the basic necessities. That is one instance, one of two instances where we can have a single transaction or single protective arrangement. The second one is what I call the property centric needs. So we may need to, maybe it's not a matter of taking care of this individual, but we need to manage their property. We need to, whether it's real or personal, we need to manage business affairs. So it may not rise to the level of food and shelter and basic care and safety, but it may be something that is in their best interest because we've got a property interest that needs to be dealt with. So, okay, so we understand the circumstances under which a single protective arrangement or single transaction can apply to, then let's delve in a little bit to the procedure. So when procedurally is Section 1121 available? Well, the opening of the statute actually gives us a clue. It says if a basis exists for the appointment of a guardian, and I'm in a proper proceeding, paraphrasing the opening right there, but it says that has to happen before you can have a single transaction or single protective arrangement. So a basis must exist for an appointment of a guardian. Well, what does that mean? And what do they mean by proper proceeding? Well, it's going to look different depending on each person's situation, and particularly the legal status of their competency. So what I mean by that is if an adult has never been adjudicated to be incompetent and in need of a guardian, then the proper proceeding to bring this action would be in the petition for an adjudication of incompetence, that very first petition that gets the whole guardianship rolling. If we already have an adjudication, and again, this would be for adults, then it's in a motion in the cause. We're going to bring a subsequent action asking for this particular relief because we know we've got a basis for a guardian. And in a lot of these situations, it may be where somebody had a guardian of the person appointed, perhaps for health care or residential decisions, but there weren't any assets to manage. There wasn't an ongoing management proposition from that standpoint, but an asset later comes to light, or somebody inherits something or is given something, or whatever reason we have an asset that comes on the picture. That's when you could file for a motion in the cause in that existing guardianship file and ask for this 1121 relief. Now, for minors, in almost every case, the proper proceeding to ask for this is going to be when you file the application for minor guardianship. It's possible you could have an existing guardianship of the estate, but I think that's pretty rare in a minor situation. So that's normally going to be done with the application for the minor guardianship, but you're going to say, well, instead of appointing a guardian, we want this particular relief. We want single transaction relief. Okay, so I think I have to stop for a second, and Julie's going to put up a quiz.
Hey, yeah, everyone get ready to, we're going to launch this poll. Kristen, you can take a break, get a sip of water as we let people click in. Prior to October 1st, 2021, the clerk could approve a single transaction without appointing a guardian of the estate. That is true or false question. And people are voting. This is good. And it is very decisive. So we're going to close it in just a second because we have great participation and we have a solid answer. Now we'll share it with the rest. Okay, closed and share. Catherine, we have 79% of people said false.
That is correct. Thanks, Julie. So it is
Ding, ding, ding.
false. Good job, everybody. Pat yourself on the back. So yes, prior to October of last year, if you just needed to do one thing in a guardianship with respect to somebody's property or safety or care, you would have to go through all of those steps that I outlined before. But now we are living in a new environment and we have new options. So I'm going to go ahead. Do I have this screen back, Julie?
You do. You're in charge.
Okay. Awesome. I can't, so y'all bear with me because I can't always tell when I'm on and when Julie's on with my view, but I'm gonna jump back into talking about section 1121, this new section that we have, and how it works. So we've talked about when is it available. We have to have a proper proceeding and to bring this in, whether it's the initial adjudication of a competence, an existing motion, the cause for an existing guardianship. Again, those are both for adult situations or application in the case of a minor. But the next question is, who carries out the necessary actions? So the court can, under the terms of the statute, the court can actually just order whatever needs to be done and not appoint anybody to carry it out. But I think from a practical perspective, we want somebody with authority to be able to do whatever it is that's intended, whether it's a Medicaid spend down, dealing with that special needs, property inheritance issue I mentioned, sign a contract on behalf of the spouse. Somebody needs to be empowered, and often somebody will have to be empowered just to get from A to B. So under the statute, we've got two new roles that for 35A. These are two things that did not exist before last October. The court can choose to appoint somebody called a special fiduciary, or they can appoint what's called a temporary guardian. Now, special fiduciaries have a little bit of a precedent in North Carolina statutes because if you're familiar with the North Carolina Uniform Trust Code, special fiduciaries pop up in about half a dozen different situations. They can be appointed by the court for very limited purposes to do a very specific thing. One example would be if a trustee is suspended or temporarily removed, let's say pending litigation, a special fiduciary can be appointed to take charge and control on an interim basis. Special fiduciary can be appointed to decant a trust. It can be appointed to have certain, limited responsibilities. The key here is limited as far as their role, and it's defined by the court. Temporary guardians, on the other hand, this is an entirely new concept in North Carolina law. And this term was really developed. It's exactly what it says it is. It is a guardian. It is an appointment of a guardian. So it falls under many of the same requirements as other guardians under 35A. But as its name suggests, it is temporary. It is of a limited duration and period of time. So it's not designed to last permanently. So let's talk about each of these and kind of understand them a little bit better. So first of all, what's the difference between the two? Well, we know that from the statute, the special authority can be appointed to execute any transaction, contract, or trust necessary to achieve, again, those person-centric goals of service, care, or safety, or the property-centric goals of property and business affairs. And then it goes down in the next section, it talks about temporary guardians and says they can be appointed to assist in the accomplishment of any protective arrangement or other transaction authorized under the section. So basically, there's absolutely no difference in their authority. So now I know you're thinking, Catherine, what is the point? Why do we have these two different offices? Well, we have them because we may need more or less authority in a given situation to carry out whatever it is, whether it's a single transaction or a single protective arrangement that we need to accomplish. And so I think it's important too to understand the requirements. I stole this chart from Meredith Smith, who did a fabulous with this UNC School of Government. She's got a fabulous blog post where she put together this table, which I think is so helpful to illustrate the different requirements when we're talking about procedures. So with this special fiduciary, you've got to have we're just going to go down from the top. You got to have an order authorizing the arrangement of the transaction. In every case, the court's got to be telling whoever this is what they are empowered to do. But they don't, special fiduciary, this is that middle column, they don't have to apply for letters. They're not going to have an order on application for letters. They are not going to have any letters or any additional documentation from the court other than that initial order specifying what they are supposed to do. Bond is a maybe for special fiduciaries. It's not required unless the court orders it. They still do have to have an oath. Fees they have to pay, just normal probate fees if they're administering assets, but they don't have to file a final accounting or report unless the court orders it. Now, shift over to the right-hand column. Temporary guardians, it's a whole different situation. They still have to have that initial order authorizing the arrangement or transaction, specifying what they are supposed to be doing. But they do have to apply for letters. There is now a new form for letters of temporary guardianship that was created by AOC right around the time that this law went live and became effective. So they'll have to apply, they'll have to get an order on application. They will be granted letters, so they'll have letters of guardianship. There'll be letters of temporary guardianship. In most cases, they will be required to get bond if they're going to be receiving property to manage, but we'll talk a little bit more about some exceptions later. Still have to file an oath, just like the special fiduciary, pay fees, and then they're going to have to file some kind of accounting or report. It can be on the AOC form, or the court could specify what type of accounting, or if it's a lesser type of accounting that they require. But it's going to look and feel, as you can see from this chart, more like a regular guardianship. The only exception is it's a limited duration, limited period of time, because we're only trying to accomplish a certain number of things. So now what you're probably thinking is, well, if the temporary guardian requires all of this extra hassle and the special fiduciary is very hands-off, why don't we always pick a special fiduciary? Well, maybe. You may want to pick a special fiduciary, but you may not. And so I think in each situation, we're going to have to evaluate who is going to be better situated to accomplish the tasks that we're trying to accomplish. And so think about what you're asking the court to do in each situation. So I gave some examples here. Are we trying to execute a care agreement, a service contract, sign another contract? Remember that example of spouses, and all we need is one spouse needs authority to sign on behalf of the other. Are we going to have to apply for government benefits for whether Social Security or Medicaid for anybody? will a spin down be needed? That will usually involve more people and more steps. Do we need to establish and fund a special needs trust? Do we need to sell or gift properties or transfers of property involved? Each one of those things you want to start thinking about what is going to be required. You also want to consider how many steps is the protective arrangement or single transaction going to require? How many different things are going to have to be done? Will a bank or financial institution be involved? Now, this is not always the case, but in my experience, banks have a better chance of recognizing somebody with letters of guardianship or that look like letters of guardianship than perhaps somebody who simply has a court order saying what they're allowed to do. So think about who they're going to be interacting with and how the likely response from the third party. The other question is, will further court action be needed? Again, that goes to how many steps are we anticipating? And then finally, would the process benefit from additional reporting or accounting? Do we have so many transactions or so many steps involved in this arrangement that we need to have some kind of mechanism to report back to the court or a mechanism just to verify when the process is done? So where I come down on this is, I think when you're trying to decide between which person the court should appoint to carry out the specifics of your situation, think of special fiduciaries as very specific instruments. They're tailored for a specific thing. The action has got to be very clear and very defined. The order is going to do most of the work for you because the order is really all you have when it comes to a special fiduciary. I think a classic example of when a special fiduciary would be appropriate is that first example I gave, where all we need to do is sign a contract. You know, we got one job, one thing to sign. We're not going to have to interact with a bunch of different people. We're not going to have to do a bunch of different things. Now, contrast that with kind of what I think is the all-purpose tool of the temporary guardian. This is where we've got multiple steps. We've got multiple parties we got to deal with. I got to get, you know, more than one person to recognize this authority and to do what we're asking them to do, whether it's a bank, whether it's a facility, whether it's a government agency. Think about those kind of things. You also may have situations where the office of a guardian is required or it's preferable. And I think two good examples are for a certain type of special needs trust, which is a Medicaid payback, or sometimes called a first party special needs trust. It is a creature of federal law, and there are only 5 people that are empowered to create this type of trust. And a special fiduciary is not one of them, but a guardian is. So that is one of those things where, to comply with federal law, you need to make sure that you're using the right office. I think when it comes to transferring property and real estate, this is just my preference, and in the ones that I've done so far, where I know somebody is going to be transferring title to property or signing a deed, I prefer the use of a temporary guardian. I just think it is a little bit more recognizable. Again, I don't want to do anything that's going to impair title or cause any kind of questions about proper authority to convey. So that's just my preference and my recommendation in those situations. So again, it's this idea of how specific is the relief that I need versus do I need somebody that's more all-purpose. So okay, so we talked about what, you know, as a petitioner you'd be considering, but what is the court looking at? And what are you going to have to satisfy the court as to whether or not this is the right relief versus, you know, the usual path, which would be a full guardianship of the estate. So you're looking at a couple things. The court's mandated by statute to look at really 3 basic things. One is interest of creditors and dependents. So that's kind of similar to gifting or sale procedures under 35A as it exists. Is anybody going to be, is any third person going to be impaired by the proposed relief that we're looking at? Now, the second one, I think, is the most important consideration of this process, especially as you're working with your local clerk and trying to get them comfortable with this type of relief. And that is, do you need the ongoing management of a guardianship? I kind of look at there's kind of like this continuum, you know, of we just need one single action, or maybe we need a couple actions, or maybe we need a list of actions, but we have a certain definitive endpoint. But there kind of there's a point on that spectrum where you're looking at this proposed relief where you're just going to need continuing management. Let's say we've got, ongoing income coming in, or we're managing a specific business interest that is going to be ongoing. We need that ongoing management and oversight authority. So that's what the court's going to be looking at. Is this person going to benefit from the continuing protection of a guardian? Now, this is a good place to stop, I think, for a second and just clarify that when I'm talking about guardianship in almost all of these instances right now, I'm talking about a guardian of the estate. But in most cases where you're looking at this, and in fact, every single one I've done so far, they've all involved adults. We've asked for specific 1121 relief as to something to deal with a property or business or financial issue that we're trying to manage without having a full guardianship of the estate. But because of that person's disability or inability to communicate their decisions, we still have needed a guardian of the person. So I just want to really flag that for y'all, because it may be that in most situations, unless you've got a healthcare power of attorney out there, or some kind of documents that allow decisions to be made on behalf of a person, medical and residential decisions, if somebody is severely disabled or severely impaired, they are going to always need the continuing protection of a guardianship of the person. But you can split those two apart. They can need continuing protection of a guardianship of the person, but they don't need the continuing financial management of the guardian of the estate. So that's what we're really talking about right there. And it's important, I think, as you're working on these issues, to walk your local clerk through that logic of, yes, we need this, but we don't need that ongoing guardianship of the estate. And then, of course, the number 3 is a no-brainer. Is it in this person's best interest? And you've got to make that case to the court too, that this is the best possible relief for this given situation. So, okay, so we've talked about that. Let's say we've convinced the court at this point. They like what we've advocated for. They like this idea. They're comfortable with using 1121. So what should the order contain? And this is, without a doubt, the most important part of the process. And not to put too fine a point on it, but honestly, the success or failure of the single transaction or protective arrangement is going to rest entirely on the quality of this order. So I want to spend a couple of moments on this, because you're going to want to give in the order the authority to achieve the single transaction or protective arrangement. You're going to want to give as many specifics about what must happen. You got to plan ahead. What's all the authority that this person might need? And there is no AOC form. And that is a very intentional decision. As we worked a lot with AOC kind of in the development of the statute, and it became apparent that, like so many of our forms kind of check the box, and, that they look very similar, and what you're asking is very similar in all these cases. But when it came to this type of relief, when it came to single transaction or protective arrangement relief, each case is going to be so unique that there is no check the box format. You're going to have to specify exactly what you want. What authority should your special fiduciary or your temporary guardian have? What are the things that they are directed to do? When is it over? What is the end point at which this person is discharged? Do they need to do any additional reporting? So you want to be really comprehensive and think through all of those steps. And I will just say, a side note on forms, if you look in the manuscript, I do go through, there were a handful of new forms that AOC rolled out last fall in anticipation of this law becoming effective. One we talked about already, which is letters of temporary guardianship. There's an application, in the application for letters of guardianship, there's a temporary guardianship box. You check, that kind of completes that set. They updated motions in the cause to kind of make it clear it's not just for modifications, but it can be for other types of relief, such as 1121. But that was really it. There weren't many other forms. And so the manuscript also goes into detail about thinking through how to use existing AOC forms, how to modify those AOC forms in all the situations where we talked about, whether it's an initial adjudication of incompetency, whether it's an existing guardianship, adult guardianship, or whether it's a minor situation. So these are not kind of blessed in any way, you know, by the clerks or by AOC, but this is just thinking through and suggestions on the best way to use the existing AOC forms, which our clerks and our assistant clerks are used to seeing, but to do it in a way where it make it very clear that we're asking for this single transaction relief. So I would just point that out. And, you know, the most important thing to remember as you're looking at this, and I probably stressed it already enough, is that for the order, precision is the key. How are we getting from A to B as far as our relief? We need to spell out each step. We need to make sure, think ahead, plan ahead, that you're giving the right order, that you're defining the scope of this, the right authority, the scope of this person's authority when it's over, and err on the side of, I think, giving more authority than less, because you don't want to have to run back to the court. You know, the whole idea is we want to just try to go to the court once or as minimally as we can. So the more you can be precise, the better it is. And if you do this at the beginning of the process, before you even file anything, if you kind of think about what steps do I need to accomplish what we're trying to do, it's going to help you determine whether you want a special fiduciary or a temporary guardian in what you're asking for. Okay, so I'm going to stop right here and let Julie do our second poll of the day.
Whoop, whoop. Are you ready? All right, poll has been launched. This is multiple choice with one correct answer. Of those listed below, who cannot be appointed to carry out a single transaction or single protective arrangement? So one of these terms you've not heard today. The other two should be familiar. Answers are rolling in. Good job, everyone. All right. Most have responded. So we're going to close it out and share the results. And they are decisively correct. Interim guardian is one who cannot be appointed in these situations. I'll turn it over to our expert.
Well, great job, guys. You got it right again. Answer C. Pat yourselves on the back. And I actually included this question because this is something I've seen come up in quite a few situations, people asking about, well, how is this different from an interim guardianship? For those of you who deal with guardianships, you'll know that an interim guardianship is another word for an emergency guardianship. And it is done even before somebody is adjudicated to be incompetent. We're kind of doing emergency relief because somebody's either person or property is in immediate danger. It's not meant to be of limited duration. It's meant to just serve an emergency interest where we're trying to protect somebody as quickly as possible. So interim guardianships are still a very different thing. And I just didn't want, you know, the terms can be so similar. I didn't want anybody to leave with any confusion on that. But remember, for 1121 relief, for single transaction or single protective arrangements, you have to have a basis for guardianship. Interim guardians don't yet have that basis for guardianship. They have a presumption that guardianship is likely to be granted, but they haven't yet proved that because they haven't yet gone through the adjudication process. So important distinction for everybody to remember. Okay, so we talked about drafting the order, what you want to think about, why it's important to kind of go through the exercise of what you want to accomplish at the outset. And I just want to run through an example to kind of show you how this is going to work. So in my example, I've got a spin down, which is really what the protective arrangement that we're looking at. So in this case, Mike has $10,000 in a bank account. He needs to apply for Medicaid to pay for his nursing home expenses. Also in that process, we need to purchase a burial policy for him and then spend on any remaining funds, whether pay over to the nursing home or otherwise, to complete the spend down and get him eligible asset-wise for Medicaid. Okay, so this is our situation. What should the order contain? So let's walk through it. And this is my big takeaway is make a to-do list. So the to-do list is going to be key. What are all the things you need at the outset? So what are we going to do? He's got a bank account. We need authority over the bank account. I would throw in there any and all accounts, because sometimes you just never know. There may be something else out there. This is where you kind of can think ahead as to, could there be any wrinkles you run into? I would also suggest in this particular situation, let's give authority to obtain additional financial information, just in case, to kind of kick the tires and make sure there's nothing else out there. Because if we just drafted it thinking that there absolutely, without a doubt, was only one account out there and we found another, well, now our order doesn't cover it. Now we got to go back to the court and get another order to do what we need to do. So again, just kind of thinking through those potential contingencies. Obviously, our person's going to need check writing authority, because they're going to have to make some purchases. They got to make a pre-need burial policy purchase. So we need authority to do that. We need direction from the court. Go buy this thing. We need direction to purchase any other items. Sometimes when I'm doing spin downs, the person may need specific things or items, furnishings, personal care items. So we want to just incorporate all of that, make sure that our special fiduciary temporary guardian has authority to make those additional purchases. They need direction to pay funds to the nursing home. They need directions probably to apply for Medicaid, or at least flag that issue if they're going to be applying right now. So that's another thing we'll need authority for. And then all of this, we've made this list. You can see the length of the list. Are we going to benefit from a report back to the court or some kind of mechanism to know when this is done, or tell the court when this is done and when this has been accomplished? So I think what's evident from looking at this, going through this exercise of making the list, is really two things. One is, you've just now outlined the substance of your order. When you get to the point of the court enters its order, this is going to be the meat of what it needs to contain and what you're going to want the court to authorize. So you basically just, done your rough draft of the order. It also tells you, just from looking at this list, I think, who is the right person to appoint for this particular protective arrangement. It's gonna, in my opinion, this is a job for a temporary guardian. We've got a lot of different people that we're dealing with. We're dealing with a bank, possibly multiple banks. We've got to buy pre-need burial policies. We're going to be dealing with funeral homes and possibly insurance brokers, purchasing possibly from third-party vendors for other items, dealing with the facility that the person is living in, applying for Medicaid, so dealing with a government agency. All of those things, the complexity of it, the fact it's going to benefit from a reporting mechanism, and we're going to need to have a defined endpoint to this, means that I think temporary guardianship is the right way to go. It's just going to give the person enough authority. I like it best from the authority is going to be recognized, or has the best chance possible of being recognized to carry out all of these steps. So I think it kind of answers your question as you go through the exercise. Now, when it comes to who should draft the order, I think essentially the person that's got the most detailed knowledge on what you're asking for is going to be the person who is in the best position to draft the order. If the petitioner is really going to be that person. If they have an attorney, that's going to be the natural person to draft the order. Sometimes you may have a pro se petitioner, but you'll also likely have a GAL involved. If there's an adjudication, guardian ad litem is always appointed. Remember, when somebody is initially adjudicated to be incompetent, and then the court, in subsequent motions in the cause, there's a separate section where the court can again appoint a guardian ad litem to verify and sign off on that the modification or the motion is appropriate. And I would anticipate, it's not required, so every county is going to be different, but I'm anticipating that in most situations, because this statute is so new and it could go, that it's got such broad variety as to how the relief could be entered, I would anticipate that your clerk is going to appoint a GAL, even if this is a later motion, subsequent to the initial adjudication. I think as a last resort, you can have a pro se petitioner draft the order. I think this is where the clerks and the assistant clerks are probably going to have to be more helpful, because the legal knowledge won't be there in crafting the language. But just think about who's going to be drafting. I think if you're representing a client in this matter, you are definitely going to be the one drafting as the attorney. Okay. So let's switch gears for a second, kind of coming towards the end of our talk today. You may have other requirements that need to be met. And I wanted to flag these especially because a good portion of them relate to real property. So I want to take a little time and talk through these additional considerations and additional requirements. So there are 5 categories which you've got to be on the lookout for if you're asking for 1121 relief. You've got to think about, do we need to do anything else? These are the 5 categories: sales, mortgages, exchanges, leases, and gifts. So let's talk about in particular, because I think this is the most likely to come up, and I think it's very appropriate too. Sales of real property. So when we're doing real property transactions, there is a subsection C of 1121, and it essentially says, and I'm paraphrasing here, nothing in this section, this new, brand new, shiny 1121 is meant to alleviate the duties of that are otherwise required in 35A for when you are doing sales, exchanges, leases, mortgages, or gifts. And you still have to follow those additional requirements. So what does that mean in the case of the sale of real property? You still have to file an additional special proceeding. There is no way around this. So you've got your single transaction relief that authorizes you to go and take this step, but 1301 is still going to apply. For sales of real property. You still have to go and take that next step and file the special proceeding. You may have to serve additional folks. You may have to serve presumptive heirs, depending on that person's situation. And this is such a big and, you are still going to be subject to judicial sale procedures and reporting requirements under Article 29A of Chapter 1. So public, private sales, judicial sales, we all know those rules and I'm sure are familiar with them. They are still going to apply. They cannot be waived. Your clerk cannot shrink it into one step and approve it all at the same time. So remember, way back when I started talking this afternoon, I started to say, we want to do one transaction or as few as possible. This is that as few as possible. So if there is a sale of real property involved, you're still going to have to do some extra things. Now, that being said, so far in my practice with 1121, I've had a couple situations come up with real estate specifically, and where we were interested in selling real property, or there was a need to sell real property. So let's kind of delve a little bit further into that when it comes to real estate. One thing I'm always looking for is, are there alternative options? There may not be. But there may be in certain situations, you kind of have to have the right fact pattern for it. So it's not the worst thing in the world if you got to go and sell real property and you have to go through that extra step. But keep in mind, and I meant to mention this on the previous slide, you may have a third proceeding required in those cases where you're selling real guardianships in one county, but you're selling real property in another. That could create a third action that has to be done. Remember, because you have your 1121 order that the court issues, then you file your special proceedings action to get permission for the sale. And then if it's in the other county, and there's a statute on point, it's 1302, then you've got to go through the sales process in the county where the real estate is located. So, again, the idea is to simplify. And so the statute simplifies as much as we can, but also think if there are some alternate solutions. And what I mean by that, I'll give you 2 examples that I'm currently working through in my own practice. One is that we just got finished with. I have husband and wife, both elderly. Wife is incapacitated. Wife has been on Medicaid in the nursing home for quite a few years. Husband has finally just left the marital residence. He is going into assisted living. She's already qualified. He had under the spousal resource requirement, so it's fine from a Medicaid perspective, and her care is going to be paid for no matter what. His care, however, he was not able to get any government benefits or assistance in his assisted living. So he needs to spend his assets to pay for his care at present. So he needs that both of them own their home together jointly, but the husband is the one that needs the funds from the sale of the house. So house has got to be sold and we need to use it to pay for husband's care. Well, in this particular situation, What I did is I asked the court in the 1121 action to authorize a transfer between the spouses. Let us deed over wife's interest to the husband. Husband who is still competent can then sell the property. She doesn't need it for her care. We're not, Medicaid's already taken that interest into account when she applied. We're not skin in the noses of any creditors that are involved. And he needs this for his care, and she's got a duty of spousal support to him. So what we did is we authorized I did a temporary guardian. We authorized temporary guardian for the sole purpose of conveying wife's interest to husband, and then husband turned around and sold the property and spent that for his care. And so we were able to avoid having to go through the sales process. And again, there's an additional Medicaid consideration that we really didn't want to deal with if the wife was selling the property and she would be deemed to be in receipt of those 1/2 funds. It could also jeopardize her Medicaid eligibility at that point. So there were other reasons that we did it. It wasn't just trying to avoid a sale, but we felt like that was the best path. And so the court approved that transfer from wife to husband. And then we were able to handle, the competent owner was then able to handle the sale privately and without any additional court involvement. The other situation that I've got right now that we haven't finished working on yet, but that just recently came up was it was the second example at the beginning of my talk. So that in that example, we've got severely disabled adult, has inherited a shared property along with other family members. He's receiving SSI and Medicaid. Those are means tested benefits. He cannot own property or cash in excess of $2,000. So we've got government benefit issues in this case. And so everybody is eager to sell this property, all of the co-owners, but what I recommended, again, because we had other, good reasons for doing this, in this situation, it made more sense I want to get this countable resource, this interest in this property out of the disabled adult's name as soon as possible. I want to transfer it into a special needs first party trust, the Medicaid payback trust, that will keep his eligibility for government benefits intact. I need to do that as quickly as possible, because whether it's land or whether it's cash for this particular situation, they're both are going to harm him from a benefits perspective. So what we're going to be doing is we're going to be asking the court to immediately transfer under 1121, under a single transaction, transfer his interest to a special needs trust. Again, deeding that interest over. And then at that point, it has the added benefit of we have a trust instrument that gives us authority for the trustee to sell, broad authority, broad power. It doesn't require going back to the court. And then the trustee can sell that person's interest in the property at whatever time is appropriate. So again, it kind of paves the way and smooths the sale of that property down the road, although there was an additional, and I think even more important, benefits consideration. But it avoided having to go through that second step of having the real estate sale. I think the trickier thing comes to situations with minors, because, when you're looking at this and trying to say, if we're going to sell a property or do a transfer or whatever we're planning to do, and it's a minor, where the proceeds ultimately going to go. So one thing to remember is that 1121 does anticipate, and it allows for paying to trusts other than a special needs trust. This is really going to come down to your local clerk and how comfortable they can feel sending something to a trust instead of to a guardianship. I haven't had this come up yet. I think probably the classic or the best case scenario would be where there is an existing trust that is created by a family member somewhere out there that is, meant to manage and protect this person's property, this minor child's property, but for whatever reason, the asset didn't get in there. If we have an existing trust and we can say, to the clerk, Your Honor, we've got a mechanism. We've got a way to manage and protect this property, whether it be cash or there be real estate, whatever it looks like, then, we've got a place for it to go, and that's going to avoid that continuing need for a guardianship of the estate. A UTMA account, if court authorized, can be in excess of $10,000. That could be an option too. In situations now, let's flip from minors to adults, and particularly those who might need nursing home care. Is it part of a spend down? So what might we sell interest in property and then need to spend down the proceeds because of a planning purpose, a government benefit purpose. These are all things you want to think about. So I don't want to say like it's you should always try to avoid having to go through that second step of filing the special proceeding and having the sales process, but just pause for a moment and think about, are there alternatives? And if the goal is to sell property, would a transfer be more appropriate? And then also, if the sale happens, if we do the sale process, where are those proceeds going to go? Because if all they're going to go is back into a guardianship of the estate, or that's the appropriate vehicle, then you really don't need 1121 relief. Then you're just going to go and have a normal guardianship of the estate and ask for approval of the sale, you know, in what we would think of as the traditional process. So okay, I'm gonna break for final quiz. I've got one slide, I think 2 slides left, and then but let's go to final poll for the day.
All righty. It's another true false question. Poll has been launched. True or false? Under Section 1121, a sale of real property will require an additional special proceeding. True or false? Catherine, we appreciate you sharing this new pathway for us. New can be hard, but this looks like it is definitely worth an investment of using when appropriate. All right, most have voted and it's a clear-cut answer. I'm going to close the poll and share the results. 74% said true. Under Section 1121, a sale of real property will require an additional special proceeding. And Catherine, we also have a question whenever you're ready.
Great. I think we should have just a couple minutes left for questions. So that is great. And good job, guys. You got it right. I just wanted to make sure everybody took away from this that you're going to have that additional special proceeding for sales of real property. It can't be condensed into one single 11 hearing or filing. Okay, so final slide. I just want to make a note about gifts, because sometimes in these types of transfers, sales, I think, and gifts or gifting, whether it's in a government benefits planning environment or just in a, you know, like my transfer from husband to wife, there's still going to have to be additional requirements met. One is, for gifts, you've still got to have approval of a Superior Court judge, so we're going to have an extra signature. And then also under the gifting statute, you're going to have to prove additional things. So this doesn't, unlike real estate, doesn't necessarily require a separate proceeding, but you've got to plan ahead if you're going to do it in one. What I mean by that is you're going to also have to show that, you know, there's certain things you have to demonstrate with respect to creditors, potential heirs, the ward's existing estate plan, that you're not jeopardizing support, and then you have to give 10-day notice that you're going to ask for this relief to anybody who's a part of the existing estate plan, a presumptive heir, or a beneficiary. So again, gifts are another one of those things that I can foresee this being used. I've used it myself so far, but you've got to jump through some additional hoops, especially if you're going to do it as one single court proceeding. You could always split it into two. And with that, I will open it up for questions. And thank you so much. I think just got a couple minutes left, but happy to answer any questions that you guys have.
Yeah, hi, so Julie here again. I'm going to read a question from someone. Feel free to be typing your question into the questions section of the bar or the chat, wherever, and you'll also be able to reach Catherine, as you see on the slide, with her contact info there. So someone has asked, so if there is a guardianship in existence for a minor child and there is an offer to purchase real estate, do you file an independent special proceeding or a motion in the cause of the existing guardianship asking the existing guardian to be appointed to handle the sale and combine the proceeds with other assets held by the guardian? And this was submitted before you answered it. I think you answered it in your
Yeah,
presentation.
so you're gonna have to, so in that one where you've got an existing guardianship of the estate for the minor, you're just gonna file an additional special proceeding and follow the statute's very clear on what the requirements are to sell that property, and you'll have to get permission in a separate special proceeding to sell the property and then go through the judicial sales process. So that really doesn't shortcut it. And I think probably in that case, if you've got an ongoing guardianship of the estate, just to kind of circle back to 1121, there's probably not a need for 1121 here unless it's a situation where you think you can wrap everything up and not have ongoing management issues with the funds that are going to be coming from that sale.
Thank you, Catherine.
Well, thank you. I really appreciate it, and thanks for the opportunity to share about this. I think it's got a lot of potential, and I think we're just kind of scratching the surface of the ways that it can benefit our practices going forward. So,
Well,
and
I
if you have experiences or stories, I'm always looking for kind of how is it working, how is it in real life and practice. Let me know.
Yeah, so email her and share as we get used to this new procedure. So thank you, Catherine, for all the preparation and that you've put into this. Thank you, attorneys and paralegals, for your time and attention today. The CLE program has been approved for 1 hour of general CLE credit or CPE credit, either one.